சென்று ஏராசா டிரைவர்ஸ் ஆப்பினை டவுன்லோட் செய்து டிரைவர்ஸ் ஆக வேலை வாய்ப்பை பெறுங்கள். மாதாந்தம் $4000 வரை சம்பாதியுங்கள். வணிக நிறுவனங்கள் ஏராசா இணையதளத்தின் மூலம் மளிகை பொருட்கள் மற்றும் உணவுப் பொருட்களை விற்பதோடு வாடிக்கையாளர்களுக்கு டெலிவரி செய்யலாம். தமிழில் தகவல்களை அறியாளையுங்கள். GTA பற்றி 40 ஆண்டுகள் அறிந்து கொண்டவரும் வீடு விற்பனை துறை ஊடாக மக்களால் அறியப்பட்டவருமான சிவா பிள்ளை. 416-854-0005. Taxi broker licensed by City of Toronto. ARASA Ride Sharing Company ARASA.ca என்ற இணையதளத்துக்கு சென்று ARASA டிரைவர்ஸ் ஆப்பினை டவுன்லோட் செய்து டிரைவர்ஸ் ஆக வேலை வாய்ப்பை பெறுங்கள். மாதாந்தம் $4000 வரை சம்பாதியுங்கள். வணிக நிறுவனங்கள் ஏராசா இணையதளத்தின் மூலம் மளிகை பொருட்கள் மற்றும் உணவுப் பொருட்களை விற்பதோடு வாடிக்கையாளர்களுக்கு டெலிவரி செய்யலாம். தமிழில் தகவல்களை அறியாளையுங்கள். GTA பற்றி 40 ஆண்டுகள் அறிந்து கொண்டவரும் வீடு விற்பனை துறை ஊடாக மக்களால் அறியப்பட்டவருமான சிவா பிள்ளை. 416-854-0005. Taxi broker licensed by City of Toronto.
Recording in progress.
Good morning, everyone. Hopefully everyone's doing great this morning. I'm just going to fix the feedback on the computer. All right, sorry, we're having some technical issues this morning. That's why we're a few minutes behind, but hopefully everyone's doing very well. Salvat is not in town today, so the $1 million question that he always talks about, I'm sure it's embedded into everyone's mind at this point. It's something that we should be thinking about every morning when we wake up and right before we go to sleep. It should be something that's embedded in our head to always think about and to always look into what needs to be done for the future. Hence, we're working under the brokerage name Home Life Future. Today, Rafael Salvakumar is here again to continue part 2 of last week's discussion. I realized last week that around 11:25 is when we ended our session. Usually it ends at 11 o'clock, and there were still around 80 individuals online at that time. So clearly this was a topic that was well needed in discussion of. So we made sure to have a part 2. We know there was a lot of questions last time that was unanswered. So please come on board. Feel free to unmute yourself and ask your questions if you can, or also just type them into the chat box, and we'll try to get to it as soon as we can. Again, Rafael Salvakumar is going to be speaking about the landlord and tenant issues, situations that usually arise, and how to, let's just say, solve them before it even becomes an issue, or how you should take part in leasing out a property without anticipating any issues to take place, or what you should do right away when an issue does arise. So those type of discussions is what we're going to be talking about. I just want to let everyone know regarding your business plan. Business plan will be a topic that's going to be discussed a few weeks down the road, right before the new year begins. That's definitely right. So business plan, do reach back into your notes of last year's business plan. We had a discussion on this before last year. We had it also early this year. We had a guest speaker come in and speak about business plans. This is something that you would want to start looking into right now. Find out if you have implemented some of the measures that you put in place back in the days. Also, you want to look into what you have done, what you have not done. Just look back at your notes and figure out what needs to happen from now on. Just give me a second. I'm just going to add the rest of the individuals online. Perfect. We have around 48 individuals right now. So again, I'm just going to recap what I just discussed a few seconds ago. Today's topic, of course, landlord-tenant issues, the benefits of being a landlord, some of the benefits of being a tenant, because we work on both sides. So Rafael is going to be continuing part 2 of that session. Remember, we're also providing in-house training nowadays. So feel free to come to the office, get to see us in person, to get definitely a better vibe, and also some coffee, anything you want. So we are indoors, and we are also continuing the virtual aspect of it. Again, the new year is about to come. Our Christmas party is about to begin. So right now, your full focus should be on what's the goal for next year. This year is basically up. We will be having a discussion on business plans in a few weeks. So that's something that everyone should attend and should have in place before the new year begins. Right now, I think everyone should reflect back to, even myself, I'm going to reflect back to the business plan that I have for my 2 businesses, and see what has to be done for this year, for the following year, what needs to be implemented, what needs to be improved, and what overall needs to happen. Because at the end of the day, regardless of how much ideas and visual aspects we have, unless we implement them, we're not going anywhere. And this is something that Salvana always expresses. Ideas, you can go and find ideas at the most place you'll ever find as much ideas would be a cemetery, because majority of the people die with their ideas, they never implement it. So in this case, we need to implement every action, every inaction that we have condoned. So in this case, look back at your business plan, figure out what needs to be implemented. Also, bring your business plan into place when we have the seminar in a few weeks from now, and let's build on that to have definitely a better future. With that in mind, I'm going to leave the space up to Rafael now. We're 8 minutes into the meeting, and we're going to continue exactly with the landlord-tenant conversations that we had. Remember, there was a lot of questions last time, so please feel free to write it back into the chat box. I have saved some of the questions, so I'll bring it up to Rafael as well. Also, feel free to unmute yourself and just continue with the discussion. And yes, thank you for joining us again.
Thank you.
Right, part 2 was definitely needed. So off to you.
It's a never-ending question, right? Good morning, everybody. How's everybody doing? Good. I am sure you guys are all happy and doing very well, and Christmas is coming. So it's the best time of the year for me, except for the weather. I never like the weather, but we got to work on it, right? So what do we do today? I mean, landlord and tenant board issues, landlords issues, tenants issues is an ongoing problem, and it's never going to end. I think it's going to be there, and we got to manage it. And the best way to manage it is to know before it happens, or when it happens, we got to take action. If we don't take action, then it becomes a bigger problem. And when it becomes a bigger problem, it's hard to resolve at the end of the day. But at the end of the day, everything can be resolved. It's about how much the dollar value. It can be settled. It rarely goes to a criminal offense. A landlord and tenant matter rarely goes into the criminal courts because it can be settled, but how much? So the landlords want to settle it for the least amount of money. The tenants want the most amount of money, right? So how do we minimize risk? How do we manage risk? How do we resolve it? That's the issue. So having said that, what do we want to do today? Where do we want to start? Any questions? Anybody wants to go anywhere? I'm ready to go. You guys know me, for the last so many years. So, I go wherever you guys want me to go. Anybody have anything in specific before I go where I think I want to go today? Nobody?
I have a quick questions, Rafael.
Yeah.
Gulzar Kassam, good morning.
Because they are never a quick question, but go ahead, Gulzar.
Okay, yeah. So it depends on your answer. My question is quick. Let's say what your answer is.
Yes.
Okay. So the thing is that if we serve so let's say if we give the notice and they agree to N11 is signed, and then they decide not to move out, what would be the consequences then?
Okay. So couple of issues there. A lot of landlords try that N11 route. N11 is one of the only forms where the landlord signs and the tenant signs, right? The only caveat on N11 is you cannot sign an N11 on the day you sign the lease. So you sign a lease today, you can't sign an N11. That becomes automatically invalid. You can sign an N11 the very next, all right? But now, what was the intention for signing that N11? Can you tell me why you signed the N11?
So the before they told us they want to move out, and let's say they want to continue now because they couldn't find something which they thought they would.
Okay. So they how long was the lease? Do you know how much time they had?
Lease was 1 year, and the 1 year is passed in last March. So
Okay.
this is like month to month now. They gave us N11 in November that they will be leaving in December, and now they're making up their minds. So I just want to make sure that that's like what could be the consequences of that.
Okay. So once they did, the landlord never asked them to move. It's the tenants who decided to move. Am I understanding that correctly? It's the tenants who decided to give the N11. It was not the landlord who initiated.
It was both ways, because we said, okay, you know what, if you guys want to move, we can move, and and they said yes, they would like to.
But here's the issue. Who started that N11 discussion is important if I have to go to the board. So my question is, was it the tenant who said, I am finding a new place because the rent is more expensive, or we bought a house, we want to move out, and it was the tenant who initiated the N11?
No, landlord did. That landlord asked them if you.
That's the important thing. That's the starting point, because everything starts there. Because if we go to the board and the tenant starts, oh, the landlord told me he wants the house because he was going to sell it, he was going to move in. Now that's a whole different discussion. That's where that's why I asked you that, because signing a form doesn't necessarily mean everything. Okay, so why did the landlord initiate the N11?
Yeah, that's right, because they want to sell the place. Yes.
Thank you. So right away, it's a wrong form. Intention was wrong. So even though the tenant signed the N11, the tenant is going to argue, the landlord never gave me the right form. because selling a property is N12. Okay, not N11. So straight away, the intention was wrong, even though just because the tenant signed something, we cannot say the tenant has to adhere to that. Because the hierarchy, the landlord is superior. He's the big boss. He knows everything. The tenant knows nothing.
Technically,
So the tenant can argue that you didn't give the right form. So having said that, so what's the issue? The tenant doesn't want to move, right?
yeah, that's just a hypothetical situation because one of my client is potentially having this. Potentially, it's not like so far they're saying, oh, we haven't found anything, but we will try our best to move out. So I just wanted to see the course of action.
Yeah, so I think the N11 is dead in the water. You can't rely on the N11 as of now. It's a whole new game, right? So couple of options for the landlord. Sell the property and then give N12, 60-day notice. That's the best course of action you can have. But here's the issue. If you give an N12 and after you sell the property. So this leads into a good topic, because all the time I get this question from landlords, all the time. It's not one, it's most of the time. Sorry, my phone. Hello? Yeah, Thambi, yeah, around. Let me be clear. Can you sell the property, a tenanted property? The simple answer is yes, you can. You can always sell your property. Nobody stops. No government is going to stop you from selling your property. But you got to deal with the tenant who is there. So what is the issue when you're going to sell a property with a tenant? If the tenant is having a good lease and his rent is reasonable, market rent, or lower than market rent, he has no intention of moving. He doesn't want to move. Why should he? So, and the second problem you have is the tenant may not keeping the property up to the level of cleanliness, neatness that you want, because tenants are tenants. So he is not going to have a clean house. You couldn't paint the house. You can't see you can't show it to a potential buyer to the full value of the house. So those are issues that you're going to face. And then with this COVID and also showings, it's going to become a problem. So the best way is to vacate the property, get the tenant out, and then redo everything, remodel and sell it. But unfortunately, you can't do it because the tenant doesn't want to move. So even though you give an N12, the N12 can only be given. I'm dealing with the situation here. I'm dealing for the tenant, because the tenant is one of my co-workers in my office at Diamond & Diamond, and I am dealing with that. Because here, the landlord came and gave an N11, the exact scenario that you're saying. Here I'm acting for the tenant. So I reverse my role, right? If I act for the landlord. So exactly that's why, Gulsa, I know this game. The landlord came one day, oh, here's N11. I'm going to move. I'm going to sell the property. You got to hear 60 days, you have to move. That's what the landlord said to the tenant. So this girl is a young girl. She's, she doesn't know anything about landlord and tenant board. She got the N11. She thought, okay, landlord is going to sell the property. I got to move out. That's what people think, right? Because they have no idea of the law. So she got that notice and she was so upset. She said, oh shit, I got 3 young kids. I got to move out. Landlord is going to sell the property. So she got this N11 and she came and talked to a supervisor in the office, and the supervisor in the office said, okay, go and talk to this Salva. I think he does landlord and tenant board. He's a stupid guy there. You can go and ask him. So she came to me, she came with the N11 and said, this is what it is, I got to move. The first thing she came to me, she said, I know you're also a real estate agent, so can you find me another place to move in? So I said, okay. So the landlord gave you N11. So what did he tell you? He said, oh, I'm going to sell the property. So I said, no, this is the wrong form. You don't have to move out. He gave you the wrong form. N11 is not the form when he is going to sell the property. And secondly, has he sold the property? So thank God I have access to MLS. I go and looked at MLS. It was not even listed on MLS. So what the heck is he trying to do here? So I said, no, you call the landlord and say, you're not moving. Exact situation. And so she called the landlord and said, we couldn't find anything reasonable in this rent in this area for now, so we are not moving. And lo and behold, time goes by, nothing happens. All of a sudden, she gets a notice of hearing for eviction, because giving a notice, remember last time I told you, you give the notice, and then depending on what type of notice you give, you have to file an application with the board. So when you file an application with the board, the tenant or the other party doesn't know that you have already filed an application. The only time you come to know that there's an application has been filed is when you get a notice of hearing from the board. The board sends you a notice of hearing saying the landlord has filed an application to evict you. The hearing is going to be held on such and such a date. So I said, okay. So and at that time, I was not retained. I was not on the file. So the girl says to me, I got a notice of hearing. I asked her, when is the notice of hearing? She gave me a date. Okay, I said, okay, let me see what is there for the notice of hearing. The notice of hearing comes out and says, the landlord has sold the property and he wants vacant possession. So I said, did you get an N12? Because you told me you only got an N11. And she said, yes, I never got an N11. I only got an N11. I never got an N12. All right. And I told you MLS, nothing is mid-sold. So I said, okay, don't worry. Let's go for the hearing. Let's give this landlord a hard time because he is playing games. The government doesn't like landlords playing games. Stop playing games. So be truthful to your tenant. Deal with the tenant in a proper manner. This is high-handed attitude. Don't do that. So I said, okay, I will fight for you. Now I am on the tenant side. So I said, and the landlord, when you give us a notice, you have to sign a certificate of service that you gave this notice to the tenant on such and such a day. How did you give it? Now, remember at the start, I told you, N11 is the only form that the landlord and the tenant, it's not the only form. It's one of the forms where you need both the signatures. And remember, when you do an N11, there is only one space for the tenant, one space for the landlord. So when you do an N11, if there are two tenants, make sure you give two N11s. Otherwise, you only gave the N11 to one person. Right? So anyway, the N11 was signed and she has the text. The landlord is saying, I am coming today to get the N11 signed. And she says, okay, I have visitors. He says, okay, I just need 5 minutes of your time. So she said, okay, come. So she signs the N11 and that's the only form you get. But when I get the notice of a hearing from the board, the landlord is saying the same day when she gave the N11, he also gave her N12. So it doesn't make sense. So I went to the hearing, I asked him, come on, you told her you're coming to sign an N11. And now you're saying you also gave her an N12. Where is the N12 in these conversations? How did you give the N12? You are making a false statement to the board. And if I report you to the what do you call that, Housing Ministry Authority who deals with this, you can be fined and charged criminally for lying. Anyway, they gave a hard time, going to the hearing. So, couple of things I argued. First and foremost, I said this hearing should not take place because the N12 was not served properly. And good thing for the landlord, one of the things he did, he didn't take 1 month's rent. Because when you want for your own use, or when you're going to sell your property, you have to give 1 month's rent to the tenant. So the landlord didn't take one of the month's rent. So he was okay in that point. In any case, we went for the hearing. So I said, first and foremost, this hearing should not go through because procedurally they didn't serve N12 properly. There's no evidence. I think the landlord realized that after giving N11, when the tenant didn't move out, he kind of made up a story and said, I'm doing N12. That's my argument in the first place. So anyway, the board member who heard it, she said, okay, I understand that. And she started going into the hearing. Okay, let's hear the other side of the story. So we started, and then I questioned about the sale of the property. Has the property been sold? Who is the buyer? Where is the buyer? I want to question the buyer. And the board member turned around and told me, you should have summoned the buyer. Board members are here and there. They're right and wrong because it's a board. So board doesn't work exactly like a court. And there's a lot of discretionary powers to the board. Because the board is not only governed by the Landlord and Tenant Act or the Residential Tenancies Act, it is also governed by the Statutory Powers and Procedures Act. So that kind of encompasses that. So they have broad discretion on how to navigate the ship. So I said to her, the board member, Madam Chair, we don't have a copy of the purchase and sales agreement. So how do I even know who the buyer is? Even if I have to summon him. On the first place, I don't think it's my duty to summon the buyer. I think the seller should have brought the buyer into the hearing. Even if you rule that I should have summoned him, how am I going to summon him if I don't have a proper purchase and sale agreement? So I put the board member on the box. So she said, yeah, I agree. They didn't give you a purchase. I said, they only gave me an amendment to the purchase and sale agreement. Because thank God, I'm a realtor, I understand what the forms are and how it goes, right? So I said, they only gave me an amendment. They didn't even give me a proper purchase and sale agreement. So how are they claiming that they sold the property? Oh, so she said, okay. All right. So what do you want? I said, I want an order that they produce the purchase and sale agreement, that they give me the contact information for the buyer so that I can summon them for the next hearing. All right. So board member said, agree. I adjourned this hearing. So the closing date, according to the seller on that, is October 29th. The hearing was taking place, I remember, around October 10th or 15th. So I said, I don't care. I need that. So the board member adjourned it. So she said, are you available somewhere in end of the month or something like that? I told her I'm going on 2 weeks vacation. I'm not available till November 15th. So she adjourned it. I've not got a date for the hearing yet. This is a live case I'm talking about. So, and also the board member ordered the other side that I should have the purchase and sale agreement and the contact information for the buyer before the next hearing. So hearing was done, adjourned. The adjudicator said, I can't help you even if the closing date is on October 29th. I can't help. Gone. So I'm still waiting for the hearing. So I came out of the hearing, 2 weeks gone. I didn't get the purchase and sale agreement. I didn't get the buyer's information. So I shot off an email to the other paralegal. About 3 days ago, 4 days ago, I shot off an email. I said, on the hearing on that day, Madam Chair so-and-so said there should be proper disclosure before the next hearing. Can you send me? Because I want to cover my side. I said, can you send me the purchase and sale agreement and the contact information for the buyer so that I can send the summons for the buyer to be present. So I want to cross-examine him on the affidavit. Couple of days later, I get the purchase and sale agreement. It all says a private sale, never done on MLS. So I don't want to say anything, but you can understand what's going on. They made up a purchase and sale agreement. And the deposit, I look at the deposit on the purchase and sale agreement. Deposit is paid not to a lawyer, not to a brokerage. Deposit paid to the seller. I don't know, Kannan, can you pay a deposit to the seller? I've never seen something like that. In my experience, you tell me, you can see the monkey business going on here, right?
In a normal transaction, no.
No, because normally, even if it's a private sale, all I know is most of the time the deposit is paid to the
Exactly.
lawyer or the brokerage.
Exactly.
So here, the deposit is paid to the seller. There's a big hole there. So I said, no, this doesn't go anywhere. This is why you should do it the proper way. Because if you got caught to the other side, you are in trouble. So I said to her, so this is what I said. Dear so-and-so, I see your purchase and sale agreement. I see a 40,000 deposit paid to the seller. In my opinion, I did say this. In my opinion, normally a deposit is only paid to the brokerage, and in this case, it's a private sale, so it must have been paid to a lawyer. But I find in your agreement of purchase and sale, it has been paid to the seller. In any case, can you give me a copy of the cashed $40,000 check? Just to see, make sure, even if I agree, right? Give me a copy of the, and it says a standstill. It's now stopped. So I don't know what's going to happen, whether she's going to produce. So when I go to the next hearing, because all this came about, I'm not saying all this came about, there was a court case that happened, exactly the same scenario, where the landlord sold his property to his brother and said, I sold it to my brother, I want this guy to go. And the guy who was the tenant was legally trained. He took it to the divisional court because the landlord and tenant board gave the eviction. He took it to the divisional court and challenged that. He said, I want a copy of the purchase and sale. I want to see how the transaction happened. I need to know how much it was paid for. And the judge said, yes, he as a tenant, every right to know what happened so that make sure this is right. So don't do monkey business. That's all I can tell you. Because if the other side is smart, they are going to challenge you and you won't have a closing date. Imagine if you can't close on the day you agree to close on the purchase and sale agreement. I see an iPhone coming up. I don't know whether it's a question. Anyway, so what I'm telling you is make sure when you sell a tenanted property, follow the proper procedure. Now, what I am doing, I wrote to the other side. And I said, here's the law. This is what it said, blah, blah, blah. You will have a tough time evicting my tenant. But I'm willing to negotiate with you. How much? And my client says, if I get 3 or 4 months, I want to go. I don't want to be staying there. So as landlords, we got to decide, is it worth to fight it? Or we negotiate a cash for keys and give something, give in return. Even if you have to, I don't know what the number is. Say, let's say if it's a tenant property, you're going to sell, you're going to get 30,000 less. Why not give the tenant 10,000, 15,000? You go. Then I get that money from this buyer. Maybe it'll work properly. So it's one of the things. And secondly, whenever you sell a tenanted property, even if it's all done right, there's a right purchase and sale agreement, it was listed on MLS, it's an arm's length transaction, nobody can question it. Even if you do that, I think as a seller, as a seller's agent, I think you have to protect the seller by inserting in a clause. I think our brokerage, each brokerage has its own clause, so I'm not going there, but at least in simple terms, make sure you put it. If the tenant doesn't vacate on the closing date, the buyer will assume the tenant. This way, you are protecting your seller. What if the tenant doesn't move out on the closing date? The buyer is going to say, you have to give me vacant possession, right? So now is another interesting question. One of the agents called me and said, I'm acting for the buyer and I want to put a clause on Schedule B or Schedule A, whatever Schedule A. I want to put a clause. He's acting for the buyer, by the way. And he's telling me he wants to put a clause in Schedule A. The buyer, the seller will give me vacant possession on the day of closing. So my first question to him is, are you acting for the buyer or the seller? I'm acting for the buyer. So why are you even going there? Why are you talking about vacant possession? Because a seller has to give you vacant possession on closing. There's nothing. So as a buyer, why are you putting that? As a seller, I will put it that if I don't give vacant possession, you attach it. So I said, don't add anything more than what is required. So my question to you guys, in our purchase and sale agreement, which clause says that, is there a clause first and foremost, says that we get vacant possession on closing? And what is the clause? Is it clause 4, clause 7, clause 8, or none of the above? Nobody wants to say it. It's clause 2. Read in clause 2. It says the seller will give vacant possession on the day of closing, on the closing date. The first line it says is vacant possession. So don't even add anything more. No need to add anything. It's already there. As a buyer, don't go and add clauses when you don't have to add clauses. You're only causing more problem for yourself. Don't add. It's already there. It's clause 2. Read clause 2 today. APS 2 starts with vacant possession. All right. So be careful. Whenever you are selling a property, be careful how you deal with it. Be honest. Number one, be honest. Straightforward. Talk to the client. And if it's a problem, it's all dollars. Deal with the dollars. At the end of the day, it's all money. Everybody, and from a tenant's perspective, they're living there. That's their house. You go and their children are going to school. They came, rented your place, hoping that they can live for some time. Continuity, tenancy. That's why the government says, even if somebody signs a 1-year lease or 6 months lease or 1 month lease, they can live there forever until they die. Because it's their house, it's their home. So treat it that way. Understand that tenants also have rights. They have some permanency. Just because you bought and sold and you want to sell and make money doesn't mean that you have to disturb their lives. But you can be fair to them. Right now, I'm dealing with another tenant. He was my client. I took him put him in the place. And now all of a sudden, the landlord decided to sell it. It's in Markham. And the landlords sometimes think that tenants don't know what their rights are. So I told the landlord, my tenant, say you will move by December 31st. But the rents are gone up. So they got to compensate for your move. Ask them for at least 6 months rent. The rent was $2,300. And I said, if they give you $2,300 times 6, even if you have to pay $1,000 more, now you're compensated in a way. And the landlord is not going to lose much, because if he in this hot market, if he gets it vacant, he can sell it for a higher price and cover up this money, right? So I said it's reasonable. 6 months is reasonable. Eventually they settle for 4. So always negotiate. There must be this. The other one, they are a little bit dumbed up. Right from the start, I said we are willing to negotiate. Come with the number. No, they all go through all this jiggery-boogery. Don't understand. Any questions so far? No, am I a tenant lawyer? I'm telling you what the facts are. Everybody is silent. Nobody wants to say anything. I'm going to get a glass of water. And then there's a bottle of water then.
Yeah.
There's a bottle of water. So this. Good, thank you. Sorry. So what's the next topic we go to? Anything else? Gulsar, did I answer your question?
Good morning, Mr. Rafael.
Yes, good morning, Mr. Delano. Nothing happened
Sir.
without a question from Delano.
Yes, I thought I'd
Yes,
end the day
yes,
like
go
that.
ahead. Yes, Mike.
My question is there a statute on limitations on what the tenant can do after he leaves the property, just in case he finds out that he has been evicted, or he has been treated unfairly and probably not with the best of intentions?
Yeah, it's called the bad faith eviction, right? So far, the tenants and landlords have been getting away fairly easily. The new issues are coming up, but at the moment, the simple answer is you should be prepared for at least 100,000. See, the initial law, the earlier law said, if you evicted a tenant in bad faith, the board can fine you up to 25,000. The board can fine you up to 25,000. So if the tenant complains and says, you know what, I was evicted, like in this scenario, if the tenant moves out, finds out later on that they were evicted, the property got sold, or the guy said, oh, my daughter is going to live there, and the daughter did not live, he finds it in KGG, he finds it in MLS, the board can only fine you up to 25,000. So that was, but the tenant, what did the tenant get? Tenant got nothing for his efforts of going and finding out, oh, they rented it out, they evicted me in bad faith. The only consolation the tenant got was they got fined 25,000. Personally, the tenant didn't get any money. So most of the tenants didn't bother. They just went away, right? Because, okay, he got fined, but what did I get? I got nothing. Waste of time sometimes, right? And so the board in Bill 186 changed a lot of things. The Ford government changed it and said, because it all came about, I think I told you last time, one of the landlords downtown Toronto told the tenants, move out, I'm going to demolish, remodel it. And one of the things, when you ask the tenant to move out because you want to repair or remodel it, one of the things that they say is the tenants have the first right of refusal. That means the tenants have the right to come back to that property at the same rent. So even though you renovated it and looks so nice, you have to give it to the same rent to the same tenants. So in this case, he evicted the tenants, 4 tenants, evicted them and said, I'm going to renovate it, move away. And what did he do? Once he renovated, he rented that property for $4,500 each. So the tenants went and said, well, you know, we were living for 1,500 or whatever it is. And now look, he rented it for 4,500. He didn't give us the first right of refusal. So what did they find? They fined $35,000. And the landlord said, here's the check, go away. And then the government said, oh shit, this is called renovation. And the government said, this can't do it. This is wrong. We have to stop this nonsense. So now what did they do? They said, we will fine you. If it's a corporation, I don't know the exact fines. I can tell you the corporation, if the house is owned in a corporation, it's a lot more fine. If it's a personal, I think the fine has gone up to 50,000. Then they also said this, we will give damages to the tenant. So now, not only we are going to fine you 50,000, we are also going to give the tenant compensation for bad faith eviction. So tenants will get 25,000. So now I have an incentive. If I'm a tenant, I'm going to look, did he sell it? Did he rent it? Because I'm going to get how much? 25,000. Not only the landlord going to get fined, I'm also going to get money. Who is not in it for it? Secondly, if the tenant was paying 2,000 rent, and now he's paying $3,000, the landlord has to pay increase in rent for 1 year. So that's another 12,000. 25 plus 12, we are looking at 37. Plus moving costs. That's why I say 100,000 number. Did I answer your question, Delano? Mr. Delano? He's gone. All right. Anybody else?
Yeah, so one question. So you said bad faith eviction. Is there like a time frame that, for example,
1 year.
1 year? After 1 year, there's no problem, right?
No problem.
Okay, thank you.
Yeah, but don't take the chance, right? It all depends on the time of discovery, right? But most of the time, if you are evicting somebody for your family's use, so family is only up and down, no sideways, no brother, no sister. Father, mother, grandparents, children. So if you say, I am evicting because they are going to live and they're going to live for 12 months, at least a year. After a year, you can do whatever you want because the government figured out that, but don't keep it vacant either. A lot of people say, okay, I'm going to evict, I'm going to keep it vacant. Vacant is not the same as telling somebody my daughter is going to live. So it's not the same thing. You're lying. So don't do that, right? But generally, if you make an agreement with your tenant, you sign an N11, you sign a side agreement, you give some money in compensation, then it's very hard for them to come back because they now know that you're going to sell it or going to do something. They came to a side agreement, they got money, a judge is not going to believe. But if you lie to them, like my case here, outright lie, you are looking at this because of Bill 186. Yes, sir.
Rafael, another question.
Yeah.
Some people find this a controversial topic of an option to get a tenant out, but the option of cash for keys.
Yes, that's
so some people call it extortion. I find it. I simply look at it as a business tactic.
yeah.
Paying the tenant, giving them. I had a client in a scenario, a very good friend of mine. It was a great time for him to sell his townhouse, an end townhouse.
Mhm.
Market, as everyone knows, peaked very highly, and he had a tenant that was nice, but didn't want to really move out. So I told him, I'm like, hey, you know what? Number one, get the proper advice. Number two, the proper advice that you'll get from someone is going to be the aspect of giving them money.
Right.
Offer them $10,000. Tell
Right.
them, be like, hey, here's $10,000 check. Why don't you move out of my property? I'll find you another one. And you know what? This is gonna pay half of your rent for that entire year, right? How could you properly proceed with such of a tactic to move your tenant out
Yeah.
to avoid any legal
Yeah.
issues?
So,
Thank you.
Oh,
One
to-
same question.
Right.
yes, so number one is 10,000 is the low end of the game,
Mhm,
right?
mhm,
Average, I am seeing about 35
mhm.
that the landlords are paying.
Okay.
The high end, I've seen 89. Right? It's especially in a case where, that's why I said, if you don't cover your stuff and put the buyer will assume and assist in evicting the tenant, and you sign the purchase and sale agreement with a deadline of closing date or whatever it is, and it doesn't move, your deal is going to fall through and they're going to sue you. So in those cases, the seller panics and he pays as much money you can extort, right? At that time, you have the fox,
Now you have no choice.
no choice, you got to pay that, right? So that's why I say, start covering your backside from the start. But you're got into trouble, that about. But reasonable about it. One of the things you do is do an N11
Mhm.
and a side agreement, right? I do that all the time, so that there is some sort of protection for the, see, look at this. You say, okay, I sign an N11, I give you 10,000, you move out. What happens if the tenant takes the 10,000 and doesn't move out?
Mhm.
You're stuck, right? So what I do is,
Don't worry.
yeah, it's okay. You do an N11, and like in this case where I'm saying that for my tenant, the landlord is now agreed to give 4 months, right? So here's how we structured it. The tenant will sign an N11. He will sign and say, I have all sort of clauses. I charge for that, doing that. But what I do is I put there, and then in this case, they're going to give him 1 month's rent on signing N11. And they will give the balance 3 months on the date of moving out.
Mhm.
Right?
Very fair.
Right?
Very fair.
And sometimes the tenants say, how do I trust? So I say, okay, give me the draft payable to that. I hold it in escrow. So at least the tenant now knows I have the money,
Mhm.
right? I keep it in escrow and I tell the tenant, on the day you move out, I'll give it to you.
Mhm.
You give the keys, I give it to you. So both sides are protected. Because if the landlord says, I'll give you, and he doesn't give, what do you do? Right? So you have to make some sort of and also you have to make sure you put clauses where they don't come after you for that, come after you for that, all that. You never know. But generally, if a judge sees that and says, okay, they got some money, they had independent choice, he's not going to rule for that.
Mhm.
But if you do something like this jiggery-booggery,
Mhm.
there you didn't even give envelope,
Mhm.
but you claim you gave an N11, and you claim you gave an envelope, and then you didn't even sell it. That is a typical case for slamming the books on them.
Mhm.
Don't do that. That's what I am saying, and it's a business, right? At the end of the day, a landlord and tenant is a business. It's a two-sided business. The tenants pay your mortgage. That's the advantage. They look after your property. Be nice to them. Deal with them in a human way. Because most of us take mortgages on these houses. So we also don't own the house. Some bank owns the house. Do they come and check every day? How are you doing? Oh, is it clean? Is the bank manager come out to your house? No, once they sign the contract, they don't even know you, right? But landlords, they have to go and check every day. Oh, what nonsense is this? Now I see, not our brokerage, I just leased a condo for somebody, and from another brokerage, I see Schedule C,
Okay.
right? And the Schedule C says, the landlord can visit the property every month for inspection. It's on Schedule C.
Okay.
So my client is a young girl and she said, uncle, you know, this guy is going to come every month.
Yeah.
I said, don't worry, sign it.
Mhm.
Don't even say anything.
Mhm.
Get it.
Mhm.
I'll deal with it later.
Yeah, yeah.
Right? Because the law says just because you sign doesn't mean he can come.
Exactly.
A judge said every 6 months also is not good. I have the case laws. So just because you sign doesn't mean, oh, the tenant agreed, I can inspect every month. Nonsense. The judge is going to say, why every month? Is it reasonable? Be reasonable, right?
Yeah. I was gonna say, sorry for jumping in, but I think I really need to express this. We need to know the law. We need to know the rules and responsibilities, because that type of information is what's going to help us. Majority of us might, come across a lot of leases, and we might avoid showing this one to our client. Why? Because there's an unreasonable clause there. But if you have the information, then you can definitely get that property for your client. There's probably going to be 10 other agents not putting an offer on that lease. Why? Because it's going to be an unreasonable landlord. But if you know the law, then you'll get that at one of the best prices, right? And you'll be laughing. It's just in the scenario that we're in right now. So knowing the law is very, very important. You have to know it all, right? But before we actually come to a conclusion that if it's right or wrong, and in this case, it's definitely beneficial for your.
But I said for as a tenant, I will sign anything.
Yeah, perfect.
I don't care because at the end of the day, whatever they write, like people write all the time. This is one of them I saw. Like even if they put every 6 months, I want to come. A judge might have said it's reasonable, but you put every month, doesn't make sense. You will never get it. If you go to court, and you may have to pay them some money for interference.
Really?
Of course. Yeah, reasonable rights of their tenant to enjoy their life. Right?
Definitely.
Don't even do that.
It's a charter right.
Yeah, charter right. Yeah. So I think, but here's what you do. If you want to go to your tenant and see how she's keeping it, or say, you have been paying my rent on time. Okay, make up a story, bullshit story. Oh, you paid rent on time. Thank you very much. I want to bring a gift to you. When are you available? Right?
100%. Yeah.
Knock the door. It might cost you $50, $100, or a gift card. And the tenant is happy. You are happy. The tenant is now waiting. When is the landlord going to come again?
Yeah, that's
right.
Yeah.
Do it the other way. Do the reverse psychology. See, get rid of this. I am the landlord. I am on this place. Get rid of that mentality, please. Right? I know
100%.
it's a business. So deal with the tenant. And if you're nice with the tenant, they're going to be friendly with you. They may even ask you to come for coffee.
I had one of my tenants buy me a Christmas gift.
Yes, there you go.
Right. Yeah, yeah.
Right. So deal with it properly. I think that's the mentality. I mean, we like you to fight because that's when we make money. Right? But at the same time, I don't need that one in the sense that, I'm just telling you what's a proper way to manage it. I mean, there are other ways to manage it, but this is. And the other one I see all the time is no pets clause. I'll come back to the question on the board a little bit later. So no pets clause. So every 1 month visit, don't put it. Even if you put it, if you're acting for the tenant, say, forget it. I sign everything. Next one is no pets. No pets clause is not valid. You can put no pets, but after you finish signing the agreement, you can bring at least maybe 3 pets. The only unreasonable thing that the board will say is if you have, like some people rent out and they breed dogs. I've seen that too. They breed dogs in the basement. That is not allowed. But if you have 2 dogs, judge might say no problem, right? But if the dog is barking, making noise, neighbors are complaining, then that's a different issue. But normal pets are always allowed. Even so, you cannot put a no pets clause. Only no pets clause that can work is in a condo. If the condo corporation says dogs of certain size, or there's no dogs. the condo corporation can restrict dogs. And they can also, under the declaration, say no pets clause. If the declaration says no pets clause, then that can be enforced. But even the condos cannot stop the guide dogs or the people with health. Even condos can't stop it, right? That's allowed. I don't know, now recently the government, like the Landlord and Tenant Board, LTB, is, they created LTB. The reason why the government created the Landlord and Tenant Board is because they wanted to get rid of these cases going to the courts. Because imagine if there's no Landlord and Tenant Board, all these courts, cases have to go to the divisional court. It'll take a lot of time. So that's why they said, okay, this is so much case coming. We don't want to deal with it in the court system. Let's create another board. Let's go there. Let's go and deal there. So less people going to the courts, more. And this is not like a court, but it's like a court. And it can deal quickly in these matters, right? Like on a typical day, there's 70 cases on the books. Can you imagine 70 cases going to the courts? And also it's cheap. It's only $186 to file a case and go to court, LTB. Imagine if you go to Superior Court, it's much more expensive. So the government did something for us and said, let's fast track these cases. Of course, it's bogged down because of so much backlog. Now, the other thing that the government has created now is I forgot the proper name, but it's a condo board. So like the Landlord and Tenant Board, they have also created a condo board right now. It's in the workings. Right now, they can deal with noise complaints, pet complaints, and all that. Because imagine if you're a condo owner and you rent a condo, you rent it to somebody. If the tenant makes problem, whether it's noise, whether it's a pet, who do the condo corporation go after? Do the condo corporation go after the tenant or they go after the landlord? Landlord. Because the condo corporation has no relationship with the tenant. So whatever the tenant's mistake is, they're going to come to the landlord. And now landlord is in problem. The condo corporation goes after the landlord. The landlord has to fight at the Superior Court. Costs a lot of money. And by the time the tenant is gone, maybe the tenant costs $10,000 worth of damages to the condo corporation. The condo corporation is going to go after the landlord and the tenant is gone. And the condo corporation says, I don't care. It's not my tenant. You brought this tenant. Our damage is so much. Give me the money. And you want to sue your tenant, go and do it. And now the landlord had to go to the Superior Court and it costs too much money. Now they created this board. So you can go to the board and deal with it in a cheap and expeditious manner. It's coming. That board is in the making and it's already 3 years. But they're slowly developing. So most of the condo problems is going to go there and not to the Superior Court. Just like most of the Landlord and Tenant Board is going to the court, not to the courts, but LTB, right? So, and one of the things, if you're renting out a property in a condo, a lot of us don't do it. Even the last condo, when I acted for the tenant, I kept quiet. But if I'm acting for the landlord, I will make sure I email a copy of the condo declaration, the rules and regulations to the tenant. Make sure you do that. Because you tell the tenant, look, you're going to live in a condo. Yes, the rules and regulations of the condo. Dog shit, you got to clean. You got to do this. You got to do that. Otherwise, if the tenant is going to say, I don't know these rules. Nobody gave me these regulations. I'm renting the condo. How many of you do it? When you rent a condo, do you give a copy of the declaration, the rules and regulations to the tenant? You think you should do it? Any smart person should do it.
It should be common sense.
It should be common sense, right? If if Selvani gives me the key,
Mhm.
I can't come and have a party. You know what I mean?
100%. When your tenant moves in, especially for condos,
Right.
make sure to advise management, make sure to advise security, make sure the intercom is set up, make sure all of documents are updated, elevator forms, tenancy package, right? Full documents of rules and regulations, all amenity details, everything should be common sense. right?
And nowadays, I get calls like the condo corporation knows which dog shit and who didn't clean.
Yeah.
And they're sending it. And they're not sending it to the tenant, they're sending it to the landlord and saying your tenant's dog went there, poo-pooed and didn't clean. It happens.
Elevators, all the cameras, they check.
They're checking, so be careful. I mean, they can do a DNA on it. So they, we take it too easily. When we own a condo, we take, it's your property, it's your, and the keys.
One question, sorry to interrupt. So when should we be giving the rules? Should it be included as part of when we are signing the rental
Yeah,
lease?
of course. The day you sign, you get your tenant, it's part of the package.
You mean it's part of the rental agreement, correct?
Rental agreement, yeah.
Okay.
And put it in the original agreement to lease, that we sign, right? Where you say the tenant will sign, nowadays we are putting a clause, the tenant will sign the Government of Ontario lease on occupancy. The tenant will also sign that they received a copy of the condo rules and regulations. It doesn't have to be big legal lug. Just make sure you put, and then make sure you have proof that you are given it. And number three, I see all the time, right? When the tenants have moved out, the landlord comes and says, oh, they damaged this, they damaged this, they damaged this. I say, yeah, okay, all right. But what did you do when they moved in? Did you do a pre-inspection? Move-in inspection? Did you go and check? Did you take pictures? Did the tenant sign saying, I got it in good condition? I came into this room, there was 4 jerseys, there was a picture, tuk. Sign. Done. So when they move out, where's that 4 things? Right? You can ask that question, right? So make sure, like, landlording is not easy. Just because bank gives me a mortgage, I buy a house, I rent it out, I'm a landlord. No. There are some rules. Read the Residential Tenancies Act. See what your responsibilities are. Make sure you follow the proper procedure. That's why these management companies are there.
So that means
Sorry,
you are saying.
the same. Sorry.
So you mean you are saying we are just the lord, we are not the landlord.
Yeah, no, you're not even a lord. You're a businessman, right?
Okay, yeah.
Right?
I have a question. I have
Yeah.
a question on the same line.
Yes,
Sometimes you have, as an owner, you have signed management contracts with the property. Say for instance, Dell Condominium, whatever the companies are. Basically, you're transferring your landlord rights to them, right? At that management agreement. So they usually do everything that landlord is doing. So in that case too, is landlord going to be ultimately responsible for whatever the tenant is doing?
Okay, it depends on what sort of agreement you have signed with your management company, right? Number one. But at the end of the day, who owns the property? The liability comes to the person who owns the property. So whoever is going to sue you, they're going to sue Victor Gamage as the owner, right? Now, Victor Gamage is responsible to, say Victor Gamage had a property. He rented it to a tenant. This is again a case law that I'm talking about. You rented it to a tenant. The tenant's dog went and bit some passerby. It's not Victor Gamage's dog. It's the tenant's dog.
Yeah.
But the tenant doesn't have insurance. Okay?
Yeah.
Now, who is the dog biting victim going to sue?
landlord.
When I
Yes.
sue a dog bite victim, all I am doing is I'm going to the land registry, finding out the owner, suing the owner. Straight away. Now I'm dealing with a case where somebody's dog was killed by neighbor's dog. But this guy doesn't know who the neighbor's address is, the name, anything. There was one case I did near the temple here, Middlefield, that big temple. When they had the party, the guy parked the car, went to see the music concert, came back on the side street. Some dog came from one house and bit this guy when he wanted to start the car. So he only knew the dog came from that address. He had no idea who the owner was. But thank God we can go to the land registry, find the owner. If it is rented, will I find the renter's name in the dog registry? No, I will sue the owner. Now, Victor Gamage has to pay that. And then he can sue the tenant.
I see. Yeah.
Right? It goes, so you can't just abdicate your responsibility to the management company and say, you're responsible. And most of the time I see these management contracts, they put everything that where they escape.
I see.
They will have one line there saying, at the end of the day, they are only there to collect your rent. I can tell you that much. And they get rid of the headache, right? If the tenant calls you, my air conditioner is not working, then that headache they take off. But other than that, a lot of responsibility still lies with the owner, unfortunately. So it's a big responsibility, especially condos. If you rent a condo, it's a huge responsibility. 99% of the time, there's no problem. But there are problems that come up. And what you need to do is to protect yourself from those problems, I think, right? I mean, any business is a risk. It's nothing without risk. Any business is a risk, but it happens. And the other thing I see all the time is, especially on detached houses, semi-detached houses, the landlords put a clause saying the tenant is responsible for cleaning the snow, cutting the grass. They put it there. It's kind of iffy. The courts have ruled that the landlord is responsible for cleaning the snow and cutting the grass. So yeah, I see it all the time. I let it go. And then there's another big one that a lot of brokerages put. First $100 of repair, the tenant will pay. Have you seen that, Kannan?
I have.
Most of the time they put Schedule D. First Schedule A, they say first $100 the tenant will pay.
What difference does that make?
Yeah, it doesn't. You can't. You can't. You have to pay. You have to provide that, right? Even they say, like, I don't know, I forgot what year the fridge should be. You can't give an older fridge too. There is some sort of thing there too. So don't put those 100. Remember, when you give, you are responsible for the maintenance. All right. So it said that. Anything else?
How about the kitchen clock or toilet clock? If they call for small things?
If it is not there, it depends on your relationship. Yeah, clocks. Most of the time the tenant will look after, right? See, imagine this. If the tenant is living and they're getting a good rent, they're not going to complain. Right? Because why should they? They know if I complain, give trouble to the landlord is trying to find ways to evict me. Right? So they will do all sorts of repairs, all sorts of things. Only the comes in when there's a high rent they are paying. They are finding it difficult to pay the rent. Then they're going to find all these small things. Oh, there's one cockroach here. Oh, one this here. So most of the time tenants are fine, but if they complain, you go and look. One of the things that the board looks at is how long did it take for the landlord to respond to a tenant's complaint about something. They're not saying you should have fixed it in 24 hours, but they're saying how long did it take? What were you doing? If tenant says there's no heat and the landlord says I'm in Florida, I'll come back in 2 weeks and have a look at it. That's a no. Right? Because heat nowadays is a necessity. So the board is going to say, okay, give him half a month's rent free because you didn't act immediately. But if you acted immediately within 24 hours or 48 hours, you brought a technician and the technician said the parts have to come from somewhere and it's going to get 3 days, right? In the meantime, you gave them portable heaters, you made them warm. The board is going to say, "Yeah, you're not getting no money." Because the landlord acted like a landlord. But if the landlord says, "Hey, you're a tenant, man, you are not even paying proper rent, I don't care." No, that's no. Yes, did I answer your question? Yes, I see a question on the board. 1 year lease is possible too. Put a clause for early eviction, i.e. in 6 months, landlord might sell the property. You can put anything you want. Vela, you can put anything you want. If I am acting for the tenant and you put that clause, I'm going to tell my tenant, sign the damn thing. Who cares? But Vela comes to me after 6 months and says, "My dear tenant, oh, you signed this?" I say, "Sorry, I didn't say it." Even if I saw it, you should have put it. See, a lot of times I think, Kanan, you come across in our chat board, people say, "We want to give short-term rentals." Right? Remember, I look at it and I say, "Oh shit, man, who's writing this?" Right? Because that's another area I want to tell you guys. In Ontario, at least, there's no short-term rentals, period. Rental is for life. Even if it's 1 day, I take you, you say your lease is for 1 day. You give it to me. I come in and I stay there for life. And if God forbid, the spouse dies, the husband can live forever or the wife can live forever. Children, 1 month. Now, how do you get around this? The only way you can get around it, and even Mark Weisleader talked about it, I think one of the seminars, the occupancy thing, and then he said, "Forget it." I even said that. You can't, it's not there. That's why he said, "Stop it." Now you guys are taking it. He talked in the context of that time, he talked in the context of you saying, I sold the property, the buyer and the seller says, "I want to stay for 1 more month before I go to the new house." So the buyer can take, you remember that one? Yeah, that's when he talked about that licensing thing. Even that is not valid, right? But
quick question.
Yeah, let me finish this round. So the board, how does it look? Short-term rentals means go to Airbnb, go to that, whatever the other platforms there are. And if you rent it there, then the board says it's short-term. If you and I sign through a brokerage or we sign a lease agreement, they say it's not short-term. The only short-term they will accept is if it goes through a platform. So if you want to do short-term rentals, 2 months rental, 3 months rental, go to a platform. Put it there. And the rent goes through and the board says, yes, this is like a Airbnb rental. This is not regular rental. But if you put something like 6 months, landlord might say, and all that, this is not. Okay, did I answer that question, Bela? All right. Basement rented for working person. After 1 year, you get married. Can the landlord increase rent too? Because now 2 people are living in the basement. Suki, to everyone. Suki, question to you. Can I have a girlfriend? Most of you say, who is going to be your girlfriend? Yeah, I understand. In Canada, you can have girlfriend, and girlfriend can have 3 kids. And they can bring all of them. And the girlfriend might have even 2 dogs. And I told you, pet is allowed. Girlfriends are allowed in Canada the last time I looked at it, right? So even though I see all the time, occupants, only 1 person. Now, right away, the working person is also not a good idea to put it, because it's a human rights violation. But if it's an ODSP, are you saying you're not going to rent it to that person? Don't even put there. You see how I get around that? By saying, you're a working person, so I'm an ODSP, you're not going to give it to me. And then you're saying I have a girlfriend and 2 dogs and you're not going to allow me to live there? No. So the only way you can get rid of people when they sign one person and they get more people is the occupancy limit of the city. If the city says in this space, there is 4 bedrooms, there can only be a maximum of 8 people, then you can evict these people. Other than that, even if you put only 1 person is going to live, 2 person is going to live, that is all garbage. It doesn't work. All right, it's okay? All right. On the lease agreement, if you state that the tenant is responsible for the upkeeping of the lawn, snow, and the city fined the tenant for not cutting grass, the tenant has not paid the fine. The fine is now included in the property tax. What can we do about that? On the first and foremost, the city is not going to fine the tenant. The city would have fined the landlord. What does the tenant got to do with the city? Right?
Landlord's the owner.
Landlord is the owner. Second and all, as I mentioned, Jaya, even though you put on the lease agreement, it's not valid. The landlord is responsible for keeping the lawn and the snow away from the property. So pay the fine, unfortunately, and start doing it. Or hire a maintenance company who go regularly and cut the, it's cost of doing business. So if you're going to rent it for 2,000 and a lawn maintenance company, snow cleaning company is going to charge you $200 every month, add it to the lease and charge from the tenant $2,200.
Can we do like a discount to the tenant if they do it? Like, so let's say if we put that in our lease that, let's say 2,200 is your thing, but I will charge you 2,000 and give you 200 discount for snow, taking care of snow shoveling and thing. And if not, then you pay me 2,200 and I'll get it done for you.
No. It's a yes and no. There is a thought that is going on where you sign a separate independent contractor agreement between the tenant and the landlord. So what you're saying is lease is 2,200. For cutting the grass and clean the snow, I'm going to give you $200 a month, but you will be my independent contractor cleaning this, blah, blah, blah. The problem to that is some people are doing it. So everything is good. Even if you put it there, you cut the snow and clean the grass and the tenant is doing it, it's no problem. It's happening okay. Everybody is happy. When is this a problem? When somebody slips and falls. There is a claim. There's a claim for $500,000. There's a claim for broken bone. There's a claim for something else. People are going to try to get money from anybody they can. Right? I work for a big accident firm. We see these accidents all the time. People go to supermarkets and fall down and they sue. So when they start suing, that's when they're going to try to find fault. That's when the lawyers are going to say, oh, this guy is responsible. That's where they make the money, right? So the question then comes, is the tenant a qualified guy to do the maintenance? What if he was mowing the lawn more and he cut his leg with the blades? And he's going to say, oh, the landlord told me to do it and he did it and I didn't have insurance. So it's a iffy, but I don't want to scare you guys, but only when there's a problem, there can be, right? So, but so it can be, at least it looks a little bit better, but the way it goes is like contractor is the best, where you hire somebody and they go and do it, there's no problem. Otherwise, you can make arrangements with your tenant, but make sure you sign an independent contract, but that can be challenged. Okay. Rafael Anna, who is responsible for removing wasp nest, landlord or tenant? Oh, it's anything to do with rodents like cockroaches, any other pest, landlord is responsible. And the landlord choosing a tenant for his house, if he personally doesn't like a tenant for some reason, how can he reject in a good manner? Good manner is say, so the question is, when the landlord is choosing a tenant for his house, if he personally doesn't like a tenant for some reason, how can he reject in a good way? That's what the question is from iPhone, wherever it is. So don't ever say you don't like them for any reason. All you can do, I think I told you again and again, say landlord is looking at more applications. He has not made his decision. He wants to see more applications. So when he is going to make a decision, we are going to let you know. And that way, nobody can say anything to you. I can make my decisions 1 month's time from today, right? Because a lot of agents will call you, I need to know the answer. And say, I don't have an answer because my landlord is not making a decision. So just in a different manner, push the ball back. Yes. No more questions?
Yes, and one question.
Yes,
For the
ma'am.
short-term lease, if
Yes.
is it furnished, we can give short-term leave rather than going to the Airbnb channel, right?
No,
No?
no. Anything you sign personally between a tenant and a landlord without a platform, it is not short-term. The only courts accept is that it was on short-term, it was on a platform, so the landlord and tenant knew it was on the platform. If not, you furnish, you make it gold, it doesn't matter. Okay, Ramu? I think Ramu didn't like the answer. I'm sorry, my friend.
No,
I have
no,
another
just,
question.
yeah, thank
Sorry.
you.
Thank you. Yes, Gulza.
So let's say if we were to do some renovation in the property and then, of course, the prices, and it's a business, as you mentioned, so we cannot be losing money every month, right? So let's say if somebody has a right of refusal before they, and I understand that we can go to landlord tenant board and say that we invested this much money. And in order to regain that, we need to get something back so we can increase the rent reasonably well, like not exactly to the market rent value at that time, but how can we go about that?
The landlord and tenant board, unfortunately, doesn't care if the landlord is losing money. He can't pay the
I don't
mortgage.
mean that way. I did not. Yeah, I understand that, but I understand. I also I know that sometimes they can go back to landlord tenant board and say I spent that much money and now I need to increase the rent for whatever
No,
reason.
What you're talking about is a different sort of increase. Above guideline increase you're talking about. Okay? What you're talking
Yes,
about.
above guidelines, absolutely.
You know, above guideline increases is basically for big property owners. Like, see, the Landlord and Tenant Act doesn't differentiate between the big landlords and the small landlords. So the Caprit and all that who own 500 apartment buildings, they follow the same rules as Gulsa who has a basement apartment. Doesn't mean the act is the act. So when they created the act, they had to create the act that covers everybody, encompasses everybody. So when they created this above, so the rent increase is 1.2%, right? And now sometimes these buildings, the big buildings I'm talking about, they need refurbishment. They need to make new elevators, maybe they have to do some major repairs to make the living condition of the houses better. And the government says, yes, we have to allow the landlord to make it better. But when they make it better, they can't just simply increase the rent to whatever they want. They have to come to us and they have to submit a proposal. I did this and I did this and I did this to make the life better. So instead of 1.2%, here's what I increased. And this was a cost that is reasonable to make the living conditions better for the tenant. So I want to increase by 3% this year. Or my property taxes went up so much, right? So that above guideline rules are more designed for them than for the small landlords. So we cannot use the same guideline. I would refrain from going there. I already gave an example where the landlord rented it for 4,500 and why they brought this 100,000 fine. Okay, who is responsible? When the landlord choosing, I did that, is 1 year short term. There's no short term. There's no short term. 1 day, 1 week, 1 month is no short term. It's all long term in Ontario.
I have another question.
Yes, sir.
From Kausar. Can we put clauses in tenancy agreements that no overnight visitors are allowed? Can you put restrictions such as that?
No.
Okay.
No. Because you cannot control their daily lives, right?
Mm-hmm.
Because what if somebody comes and it's normal? No. Only thing is overcrowding. Like overcrowding is a reason for eviction, but it's a very high bar. I have evicted a tenant for overcrowding in Mississauga. The only reason I was able to do that guy was a professional basketball player living in Florida. His mother was running the property for him in Mississauga. And what did they do? They divided the whole house into different rooms. Even the living space they converted into bedrooms. And they were paying 2,500. They were making like 6,000 a month. They rented the basement. They did everything. And the landlord said, oh shit, man, these guys are, and how do they advertise? They do it very sharp way. If the address is number 12, whatever street it is, they will put in Kijiji, number 11, that street, available for it. And when the tenant calls, the prospective tenant calls, they say, yeah, it's a mistake. It's actually 12. And they will show 12 and they rent it like this. And so you couldn't find in Kijiji the damn thing. But fortunately, the landlord is able to go and get pictures inside, brought it to me, and I went to the hearing. I had to look at the occupancy clauses for the Mississauga property standards, where they said how many square feet, how many people can live. And there is also a clause, you can't convert open space like a living room, a kitchen into a living space. You cannot. Only bedrooms are allowed to people to sleep. So if you convert your parlor room into a room, that's not allowed. So I had to get all those laws, go to the board and show to the member, here's the law from the Mississauga Property Standards Act. Here's what the pictures are showing. And I wanted an eviction because the board member doesn't know what's happening. So on that basis, I was able to get an eviction. So overnight, to get an eviction overnight person, very hard. Yes. Anybody else? Somebody was talking. No?
I have a question.
Yes, sir.
The rent increase, any different new building and new
Yes,
house
yes.
or old?
Yeah. November 15, 2018. November 15, 2018. No rent increase guidelines. It might change. It might change. It's all provincial regulations, right? Did you guys follow in Prince Edward Islands? There, even if the tenant moves out, you cannot increase the rent. In Ontario, we have vacancy decontrol. So if the tenant is there, he's paying $2,000 rent, is in an older building built before December 15, 2018. If the tenant moves out, if it is 2,000 rent, as far as the Ontario law is concerned, you can increase the rent to any amount to the new tenant. That's called vacancy decontrol. Once the property becomes vacant, the rent is not controlled. But in PEI and in Ontario too, before, there was no vacancy control. So if the tenant was living for $2,000, if the tenant moves out, the new tenant has to be $2,000. Imagine that. That's the law in PEI. That's the law that was law in Ontario too. They just changed it for us and brought in vacancy control. NDP is saying, get rid of the vacancy control. So if somebody is renting a property for 2,000, they have to rent it for any new tenant at 2,000. NDP is asking for it in the new election, but I don't think they will get it, but that's something is in the air. All right.
So the new.
But the Ford government did that for new, because why they did it is because they thought if they take out the rent control, lot of builders will build houses like what do you call the rental buildings, rental apartments. So when they build too much rental apartments, the rents will come down. That's their thinking. Okay, that's what the government is thinking. That's why they brought that 2018 law.
Okay, so the new building can increase
Any amount. As far as right now, you can increase any.
The condominium. too.
Condominium, any condominium occupied after November 15, 2018. All right. During winter, if landlord can shovel snow and during a lease listing, someone falls on the property and goes to claim for the fall, what can the landlord do? Send it to your insurance company, right? That's why we have insurance, right? We should have insurance, and that's why when somebody falls, the insurance company has to take it, right? And the insurance company will cover it. It's for negligence. And unfortunately, you know, your premium will go up. All right.
Can you tell the tenant insurance about the
Yeah, tenant insurance, you can ask for it, right? So here's the deal. You can ask, the landlord and tenant board doesn't say that it is part of the requirement to rent to somebody. But they are not going to say you can't ask for it. You can ask. And the problem is, if the tenant doesn't pay the premium, it's like $50 nowadays, right? 45, $50. And if the tenant cancels it next month, you don't know. So if there's a claim, it'll come, as I said before to Gamage, it'll come on your head. So you have to pay the claim. And then you try to recover from the tenant. It's a different game altogether. Subrogation rights. All right.
So one question I have. So first of all, you know, thank you so much for this. Is the second time you're doing. Thank you so much.
You're welcome.
So one question is now, I know you have given all the scenarios, and basically the owner is basically a lord without a land. So now, if a person, if the landlord wants to remove a person, say for example, he had 1 year lease, and that lease is done, and the tenant is still staying month to month. So what is the best way to tell the tenant, please leave?
Hello. So, as I said, unfortunately, there is no such thing as you can get rid of a tenant after 1 year lease. I mean, I've been saying that again and again, and a lot of landlords still don't agree with that. I don't agree with that, but the government says that's it. 1 year lease doesn't mean that 1 year lease ends at the end of the term. The only reason the 1 year lease is good for you or good for the tenant is for 1 year, if they move out between 1 year, you have a right to claim against the tenant for breaking the lease, right? It's very hard. I tell you not to do it, but you can try, right? If the tenant signs a 1 year lease and after 6 months, he says, thank you very much, bye-bye, I'm going. If it's a normal lease, if it's like a $5,000, $6,000 lease that you sign with a corporate client, by all means, go after the corporate client because you can get that money. It's a lot of money, right? For 6 months at $5,000, $6,000 a month, it's a substantial money that somebody will fight for. If it's a $1,500, $2,000 rent, and if the tenant moves out tomorrow and all you're going to lose is the realtor commission, forget it, bite the bullet, find a new tenant and go ahead with it, right? That's number one. Number two, the reason why a 1-year lease works for a landlord is one of the reasons you can give a notice to a tenant to go is if the tenant is persistently late in paying rent. That means if the tenant is supposed to pay you rent on the 1st of the month, every month he is paying on the 5th, he is paying on the 6th, and he has been doing it for 6, 7, 8 times. At the end of 1 year lease term, you can serve them a notice called N8, which says they have been persistently late in paying rent. And that is only you can evict them after the end of the lease, not before the end. Now, to do that, it's not as simple as I have said, because what you have to do is you have to document everything. So every time the tenant is late paying rent, you should have given an N4. So the tenant didn't pay on the 1st, on the 2nd, boom, you give the N4. So you accumulate those N4s, and then with the N8, you file that, and then you go to the board and say, his lease is finished, he has been late paying rent 8 times in this lease agreement, I want him out. And that application you can only bring at the end of the lease. When you bring that, doesn't mean it's an automatic eviction. So I've done that. So when you come that, what the judge is or the adjudicator is going to say is, okay, this man has been late paying rent 8 times, but he has paid you. So let's give him a chance. From now on, he has to pay you rent on time. If he doesn't pay rent on time from now on, then you can evict him. And they might give an eviction after that, right? So they will give them an opportunity to clear that, because they're going to say, a lot of tenants are not even paid the bloody rent. Hey, at least this guy pays you after 5 days, right? I have files, they have $50,000 in areas. So what's the problem? I mean, that's a problem. So first and foremost, we have to understand, I think that's where the problem starts, right? We have to understand that if you give a tenant, we should have an understanding that this tenant is going to live there for a long time.
Raphael?
Yes.
Lal speaking.
Yes.
Quick question. How are you guys? Quick question. Most of the problems I see with the tenants before they move out, say they've been there for like a year. Say for the first, and then before they move out, they file a complaint saying it wasn't livable. Is that how would you deal with that? You've been there for a year and all of a sudden you complain about not livable.
Okay.
Sorry. Thank you. Thank you, Raphael.
Yeah. So those are tenant applications you're dealing with. The tenant is given 1 year to bring a complaint. So if the tenant says, today, he files a tenant application for not providing essential service. The landlord didn't cut the grass, or the landlord. So one of the things I see is landlord told them to cut the grass and clean the snow. So they claim $100 or $150 a month from the landlord, right? Because landlord didn't do it. It is his responsibility to do it, but he never did. So I am going to charge $150. Now I lived there for 5 years. I cannot claim $150 for 5 years. I can only claim from the date of complaint back to 1 year, right? It's a 1 year limitation. So anything that happened from the day I complained to 1 year before, I can claim. So 150 times 12, I can claim, or the tenant can claim. If there's no heat for 3 months, or he didn't heat it up properly, I can claim for 1 year from the date. I cannot claim anything before, right? Or
there was a water leak, he didn't repair, I had to live with this damage, I can claim for 1 year. Everything has a 1 year limitation, but you have to have proof. And most of the time, these abatements are not 100%. Because the judge is going to say, even though that house was not clean, and the house has mold, the house has this, you still live there. So in the good old days, most of the time it's only a 20% rebate. Nowadays, I see more like the 50% range coming in. So maximum that landlord will be responsible, I think, if you show you did this, I think the landlord will be responsible for 50% of the lease, if the tenant has all the documentation. But they can only go back 1 year. Did I answer your question, Lal? All right.
Yeah,
Thank you, Raphael.
Yeah,
Thank you, brother.
Rafael again asking that question. So looks like then what we are hearing is it is your good luck if you put a tenant and he vacates after 1 year or 2 years, right?
Yes, yes. It's not good luck. I mean, he paid you for 1 year, and then you if you really don't want tenants for a long period of time, go Airbnb route.
Pardon?
Go through Airbnb.
Oh, okay.
Yeah.
So
if
that
you don't want a tenant for a long time, and you feel go on the platform. But unfortunately, in Toronto, they have the new rules that you cannot rent on Airbnb your investment property in Toronto, but outside Toronto you can do it.
But then why do we, okay, so one lease we are putting so that we can give some notices, that becomes a reference point. Otherwise, looks like the rental lease putting in 1 year or 2 years, that does not even hold, because the tenancy is for life, looks like.
Yes. The notice purposes, you got that right very clearly. For notice purposes, 1 year term is important. Like imagine you want to sell the property. You cannot say you rent it for 1 year. 6 months down the road, you cannot give the tenant notice you're going to sell, your property is sold, you got to move it for owner's view. Because the tenant can say, no, I can live up to 1 year, right?
Okay.
So the earliest time, say, suppose the tenant is from January to December, right? And you want to give the tenant notice in 12 or in 13, right? The earliest time you can ask this tenant to give notice is 2 months before. So December, November. You should give the notice on November 1st or before to move with the termination date of December 31st, right? Because he has a 1 year lease. So these notices can only be given for an ending date of December 31st. You don't have to wait till December 31st to give the notice. You can give here, but the ending is December 31st. Make sense?
Yeah, so looks like it's our agents' good luck that the clients do not know, otherwise they'll not buy investment properties from us. It's like back home, once a person comes in, he's not going to leave. Just kidding, eh? So in summary,
no, I think knowing is important, right? Than not knowing and then coming to know, right? I think, before marriage, you better know whether your wife can cook, can clean, and do the laundry and all that, right? And once you get married, you're stuck.
And vice versa.
Vice versa too. Yeah, thank you.
Vice versa. Yeah. So in summary, what you're saying?
Yes. In summary, I'm saying know the rules. That's all.
No, or they will not leave, or if somebody stays there.
Here's the issue. At the end of the day, what I see is the landlord and tenant issues are more now than they were 5 years ago. Okay? 5 years ago, we had less cases, less issues. The tenants and landlords were living amicably. Within the last 5 years, we have seen a sharp increase in these disputes. And also, during the last 5 years, we have seen a big increase in rents. So the problem is not landlord and tenant relationship, I think. The problem is lack of supply, lack of housing. The underlying cause of all this is not enough houses. for tenants, or the tenants are unable to afford the rent. And that is why we have this escalation between the problems between landlord and tenant. Right?
Yeah, because tenant doesn't.
That's why the government is interfering and trying to fix it. So once we get into a normal market where the tenant can say, you want $200 more? Screw you. I'm going to that landlord, right?
Yeah. So
when that
he
happens,
has.
things
Yeah,
will come.
they have no intent. They have no incentive to move out, right?
Right. For now,
Tenants are
because
moving,
if they got a good rent, they got it 5 years ago, 10 years ago at a reasonable rent, they have no intention to move out because the rents are higher. But if they get into a tenancy agreement today with a high rent, right? Imagine the reverse owner situation. Today, if somebody is renting, they are renting at the high rent, right? They are not renting at the low rent. Yes? Everybody agree with me? So if you're renting at 3,000 right now, and the market suddenly changes, and there's no more rental properties coming into the market. So now they can find for 2,500. You don't have to tell them to move. They will call you and say, my dear friend, come and take over your property because I'm going to my neighbor's property, your neighbor's property for 2,500, right? And that might happen. And then we will have less tension. So I think at the end of the day, it's not about knowing the rules. I mean, that's my humble opinion. It's about supply and demand, how it's going to go. And if the tenants are renting at a high rent and they find a low rent, the tenants, tomorrow they will move. And then you are going to beg them and say, can you say a little bit? I give you less rent. It happened in downtown condos at one time. A couple of months ago when the pandemic started, the tenants started moving out because they could find a cheaper rent on the next condo. And I acted for a landlord and I told the landlord, call them and say, you will take $200 less because these are good tenants. The market rent is less. So keep them, right? And once that happens, this tension will go away. And that's what the government is aiming. They are working on it. If there's no overnight solution, but it might happen. Make sense? Doesn't make sense.
Perfect. So we'll start wrapping it up.
Yes, my friend.
There's one more question
Sure.
that we have here. During the winter, if a landlord can't shovel the snow, and during the lease listing, someone falls on the property, how do you take care of such a claim?
Again, insurance.
Perfect.
Go and deal with the insurance because it depends on liability.
Mhm.
It can be depends on where they fell, whether they fell on the city walk up. It's for the lawyers to figure it out.
Exactly.
So that's why we have insurance, and make sure your insurance is valid.
Perfect.
And you're okay.
Exactly. Last one: if the tenant pays the rent but doesn't pay the utility bill, what notice? What would be the procedure?
Yeah. This is one of the things that they brought the change 189, that you can now go for utilities separately.
Nice.
Right. It's an N10 notice, right? And it is still in the working, but you can go and claim utilities. N10.
Raphael, quick question, brother.
Yeah.
Raphael, what would you recommend? Say you sign a lease for a year, correct?
Yeah.
Say the client wants to give you a year in advance, the whole money. Would you accept it, or would you just say, no, just give a year lease, pay me monthly?
Okay.
Which one is, which?
Okay. Yeah. Good question. Good question. According to the Act, the only rent the landlord can receive on a lease is first and last. And if there's a key deposit, those are the only three things you can receive as per the Act. So what happened is, this is again a case law. A lady came from UK, somewhere in Mississauga, I think. She rented, and her rent was some $1,000. So she paid, because the landlord said, you have come from UK, you are a new person, I don't know, you're saying you're going to get a good job, I don't know. Pay me 1 year rent in advance. And she paid. But after she moved in, she went to the landlord and tenant board and complained that the landlord asked me to pay more than what is required in the Act. The Act says first and last, And if there's a security deposit, it's only, but this is a house, there's not even a security deposit. So she said, landlord should refund my money and I'll pay him monthly. And the board agreed. Board said, yes, landlord is wrong. He shouldn't have asked. Now, on the other hand, if you volunteer, the landlord shouldn't ask, but the tenant can volunteer. Two different things. Landlord can say, I didn't ask, but she gave me. Then it's okay. So don't ever ask as a landlord, in paper, in public, in record. But if they offer by volunteering, then if you accepted it, yes, it's good to keep. All right, I think, Kannan, I mean, good, everything good, everybody's happy, somebody's not happy, I know, that's our role, my friend. You know, you come to us, we have to tell you the truth. You know, we don't want to say, yeah, and dance, right? But I hope you had some information.
Definitely. And
so end of the day, Raphael, you're saying it's your own choice. If the client comes up to you and says, you know what, I'm willing to pay you 8 months in advance.
Yeah, you can take it, but don't ask. Don't ask on record.
Correct. Yeah.
What if say within 8 months they do a lot of stupid shit in there, right? Sorry for the language.
That's a different question.
So what would you do in that one, brother?
Yeah,
but you already took it. You can't kick them out now.
You select your tenant, make sure they're not going to damage it. That's number one. Screen your tenant, don't give it. But most of the time, the tenants who are going to give you this type of money, they are good tenants.
Okay.
All right.
Yeah, like there's no 100% right path that you can take when you're choosing a tenant. No one knows what issues may come after. I had a tenant, a wonderful tenant in my Bowmanville property, paying perfectly all the time. And then it came to a point due to COVID, she was out of a job. And at that point, we're investors here, right? We're the landlord, we're investors. I don't even look at myself as a landlord, but we're investors here. At the end of the day, the tenants that we have are human beings as well. I look at at this being my house, but that being their home. So there has to be a little bit of respect that we give. At the end of the day, it's a business transaction. It's an investment for us. We can't know exactly what turmoils, what issues may take place down the road, but we just got to make sure we do the right things right when that starts. So knowing your rights, having the right information and access to information is number one when it comes to dealing with investment properties, helping our investors, our clients with their investment properties. So again, thank you so much for everyone joining today. Raphael, wonderful to have you again.
Thank you, my friend.
And we'll definitely have more of these sessions. With that, enjoy your weekend. Take care. Bye now.
Bye-bye. Bye, guys. All right, everybody's happy?